friend, how are you? I'm Advocate Gaurav Kumar Gupta. I am Chartered Accountant and MBA Finance and PhD holder. My project डेरिवेटिव मार्केट फ्यूचर ट्रेंड एनालिसिस। आज हम टॉपिक डिस्कस कर रहे हैं वो बेल पिटीशन के बारे में डिस्कस कर रहे हैं। ग्रांट ऑफ बेल रूल ऑफ 83 को बता रहे हैं। कंसिडरेशन ऑफ बेल एप्लीकेशन 83, when bail cannot be granted 84, anticipatory bail 84, principle to be taken into consideration. Grant of bail, court should be reason section 47 CRPC. Bail, successive application order guaranteeing bail on ground that accused has been custody for period of 3 years. Successive application of bail, cancellation of bail 439 of CRPC. ग्रांट ऑफ बेल का रूल ऑफ क्या है? ग्रांट ऑफ बेल, द कोर्ट जनरली टेक इनटू कंसिडरेशन द नेचर ऑफ द चार्ज। ग्रांट ऑफ बेल के लिए जो नियम होता है, पहले चार्ज का नेचर को देखेंगे। द नेचर ऑफ एक्विजिशन को देखेंगे। द नेचर ऑफ एविडेंस इन सपोर्ट ऑफ द एक्विजिशन, द severity of the punishment to which the accused may be subjected, the danger of the accused abusing the conscience of bail, way of absconding, tampering with the evidence, health, age, set of the accused, the social position, status of the accused and complaint party, last but not the least, whether the grant of bail would the course of justice. Consideration of bail application, the following relevant factor to be looked into. Gravity of the evidence की gravity को देखेंगे। उसके बाद आइए नेचर ऑफ एविडेंस के नेचर्स क्या हैं उसको देखेंगे। अदर पेकुनर circumstances, possibility of the accused jumping out the bail, his ability to tamper with evidence। के चंद्रा वर्सेस स्टेट ऑफ 1993 में क्राइम 149। वेन बेल कैन नॉट बी ग्रांटेड, बेल कब ग्रांटेड नहीं हो सकता? वेयर देयर वेयर सीरियस एलिगेशन ऑफ इंटरनेशनल रीमिफेक्शन अगेंस्ट द एक्यूज एंड प्रोबेबिलिटी ऑफ completion of investigation taking a long time, it was held that bail ought not to be granted. Anticipatory bail, the necessity of introduction of section 430 of the CRPC was mainly for the purpose of in fight between influential person with the object of maligning other and bringing case for the sake of detaining a person for some days. Principle to be taken into consideration. The following are the principles and the matters to be taken into consideration for refusing, guaranteeing, and anticipatory bail. The court must be courteous and circumspect in exercising the power of grant of anticipatory bail, because the said bail to some extent interferes with the investigation of the crime. The proposed acquisitions appear to stem not from motive of furthering the end of justice, but from some ulterior motive, the object being of injure and humiliate the applicant by him arrested. A direction for the release of the application on bail in the event of his arrest would generally be made on the other hand if it appear likely, considering the antecedent of the applicant, that taking advantage of the order of anticipatory bail, he will feel for justice such an order would not be made. The consideration which are relevant from the grant of bail after arrest are also relevant in regard to grant of anticipatory bail. There is no bar to grant of anticipatory bail in respect of economic offence. Grant of bail. Court should reason section 437 of CRPC. Giving reason for guaranteeing bail to accused is different from discussing merit or demerit. At the stage of guaranteeing bail, a detailed examination of evidence and elaborated documentation of the merit of the case has not been undertaken. In the instant case, what the additional session judge has done in the order guaranteeing bail was to discuss the merit or demerit of the evidence that what was the depreciated by the High Court that did not mean that list grant guaranteeing bail. Some reason for prima facie concluding why bail was guaranteed need not have to be indicated. Bail successive application. Order guaranteeing bail on ground that accused has been in custody for a period 3.5 years. Section 47 of CRPC. In the instant case, accused had earlier made 7 applications for grant of bail which were rejected the High Court. Some such rejection have been affirmed by the Supreme Court also. When the seventh application for grant of bail was allowed by High Court, the same was challenged before the Supreme Court. The Supreme Court accepted the said challenge by allowing the appeal filed by the Union of India and other and cancelled the bail granted by the High Court. While cancelling the said bail, the Supreme Court specifically held that the fact that the accused was in custody for more than 1 year at the time, and the further fact that while rejecting an earlier application, the High Court had given liberty to renew the bail application in future were not grounds envisaged under Section 47(1)(1) of the Code. The Supreme Court also in specific terms held that condition laid down under Section 437 Clause 1 is sine qua non of for guaranteeing bail, even under Section 439 of the Code. In the impugned order, the High Court has given the period of incre in creation already undergone by the accused and the unlikelihood of trial concluding in the near future as ground sufficient to enlarge the accused on bail in spite of preposition हो गया के बावजूद to fact that the accused stand charge offense punishable with life imprisonment even death penalty. In such cases, the mere fact that the accused has undergone certain period of increation 3 by 1 by 2 years in this case by itself would not entitle the accused to being enlarged on bail, nor the fact that the trial is not likely to be concluded in the near future either by itself coupled with the period of increations would be sufficient for enlarging the accused on bail when the when when the gravity of the offense alleged to sever and there are allegations of tampering with the witness by the accused during the period he was on bail. Successive application of bail. Duty of court. Section 437 CRPC. Though an accused has right to make successive application for grant of bail, the court entertaining such subsequent bail application has a duty to consider the reason and ground on which the earlier bail application were rejected. In such case, the court also has a duty to record what are the fresh grounds which pursued it to take view different from the one taken in the earlier application. In the impugned order, no such fresh ground recorded by High Court, while the guaranteeing bail. It also failed to take into consideration that at least on 4 occasions, order referring bail has been affirmed by the Supreme Court, and subsequently when the High Court did grant bail, the Supreme Court concealed the said bail by a region and order. The impugned order indicate any of the fact that the High Court took note of ground which persuaded the Supreme Court to cancel the bail on earlier occasion. Such approach of the High Court would be violative of the principle of binding nature of judgment of Supreme Court rendered in lies between the same party and the fact tends to ignore and thereby render ineffective the principle enunciated therein which have binding character. Cancellation of bail, Section 439 of CRPC. When a person to whom bail has been granted either try to interfere with the course of justice, attempt to tamper with evidence witness, their threatened witness, indulgent in similar activity which would hamper smooth investigation, a trial. Bail application अंडर सेक्शन 25 आर्म्स एक्ट 1959। बेल एप्लीकेशन को एक्यूज इज जेल, जब एक्यूज जेल में है तो इसके लिए आपको कैसे बेल एप्लीकेशन लिखना होता है। पहले लिखेंगे इन द कोर्ट ऑफ सेशन जज, एप्लीकांट को लिखेंगे राइट साइड में, लेफ्ट साइड में इन द कोर्ट ऑफ सेशन जज, राइट साइड में एप्लीकांट, उसमें लिखेंगे एम वर्सेज द स्टेट ऑफ उसके बाद लिखेंगे अपोजिट पार्टी, फिर क्राइम नंबर लिखेंगे, उसके बाद अंडर सेक्शन 25 आर्म्स एक्ट 1959 लिखेंगे, पुलिस स्टेशन पीएस लिखेंगे, उसके बाद लिखेंगे रिस्पेक्टेड सर द हम्बल बेल एप्लीकेशन ऑन बिहाफ ऑफ एबव नेम एप्लीकांट is as under that this is the first bail application and the application is not previous court। दूसरा पॉइंट लिखेंगे that the bail application of the applicant is neither pending in high court nor has moved his bail application through other counsel during the pendency of this bail application। तीसरा पॉइंट लिखेंगे that according to the prosecution the applicant was arrested by the police station on at 3 am, जो टाइम है वो लिखे हैं इन द मॉर्निंग, ऑन कंट्री मेड पिस्तौल अलॉन्ग विथ cartridge recovered from his possession। According the first information report, FIR was lodged against him giving rise the crime number of dash of police station। चौथा पॉइंट लिखेंगे that the applicant was neither arrested on the spot nor any recovery was made from his possession as alleged by the prosecution। पांचवा पॉइंट लिखें that the recovery memo was neither prepared on the spot nor the copy of the recovery memo was given to the applicant। The recovery memo is aforesaid document। सिक्स पॉइंट लिखेंगे that the applicant was from his house on dash of 10 p.m. evening by the police station was Allahabad and was illegally detained from that police station when the applicant refused to the police witness against P is police case। 7 point लिखेंगे that the applicant is quite innocent and has been falsely implicated on account of local protibandi of the village। 8 point लिखेंगे that the prosecution stay is totally false and connected one। 9 point लिखें that the applicant is ready to furnish reliable surety। उसके बाद लिखेंगे प्रेयर में लिखेंगे it is therefore humbly prayer that your honor may be pleased to release the application on bail that। उसके बाद लिखेंगे काउंसिल ऑफ एप्लीकांट। अगले वीडियो में हम आपको डिस्कस करेंगे बेल एप्लीकेशन अंडर सेक्शन 3 या 4 डोरी प्रोविजन एक्ट 1961 एक्यूज इन कस्टडी। जब एक्यूज कस्टडी में है डोरी प्रोविजन में सेक्शन 3 बेल एप्लीकेशन कैसे अप्लाई होता है, उसके लिए कौन से कोर्ट है, तो इसका एडिशनल म्युनिसिप मजिस्ट्रेट यहाँ बेल फाइल होता है। बेल एप्लीकेशन नंबर 1 आपको बताए थे आर्म्स एक्ट में बेल कहाँ फाइल होता है, कोर्ट ऑफ सेशन जज। 3 प्रकार के कोर्ट होते हैं जो हायरार्की होते हैं क्रिमिनल कोर्ट के। कोर्ट ऑफ सेशन, जुडिशल मजिस्ट्रेट फर्स्ट क्लास सीजीएम को पावर होता है चीफ जुडिशियल मजिस्ट्रेट को 7 साल की सज़ा सुनाने का पावर होता है। जुडिशल मजिस्ट्रेट फर्स्ट क्लास कोई भी केस को ट्रायल कर सकता है। कमिटल प्रोसीडिंग जो होता है जुडिशल मजिस्ट्रेट कोई भी केस को ट्रायल कर सकता है, लेकिन जितना सज़ा होगा जिस मजिस्ट्रेट को जितना पावर दिया गया उतना ही सज़ा के लिए वो कमिटल करता है। तो जैसे सीजीएम को पावर है 7 साल का, यदि किसी को 10 साल का सज़ा हो जाता है तो उसको कौन ट्रायल करेगा, जुडिशल मजिस्ट्रेट फर्स्ट क्लास। तो केस किसी भी केस का इन ट्रायल कर माने ट्रायल कर सकता है, लेकिन कमिटल करने का पावर सेशन कोर्ट को होता है। तो वो कमिटल पावर होता है कि जुडिशल मजिस्ट्रेट यदि वो सेशन कोर्ट को कमिट कर देता है, माने उसको ट्रांसफर प्रोसीडिंग कहते हैं। इस प्रकार से लॉ हमारा चलता है। अगले वीडियो में हम और भी बेल पिटिशन के बारे में, बेल पिटिशन कैसे लिखाता है, बेल बॉन्ड कैसे भरा जाता है, उसके बारे में हम आपको डिस्कस करेंगे। आज का वीडियो यहीं पे वाइप आउट करें। डेट्स ऑल।